So the first requirement is what is it? Uh, Before we start drafting any contract, what we should be aware of. Uh, that is something that we must take care of before even considering to put any word on the draft. So, what these can be? So, essentially, it is the transaction. So, let's say if we are not aware of the transaction that parties are going to uh, enter into, then we cannot draft a contract. Then we should also know the details of the parties. Those details uh, can be of a person or it can be of a company. Uh, so we have to capture the essential details of that individual or the company. It can be a name and some identification and address, or in case of company, it can be uh, the name, address, or registration details. Then, before we start the actual work, we also have to think about what parties have negotiated, what type of transaction it is. For example, if it is a transaction for, let's say, sale of an immovable property, or is it a transaction for, let's say, licensing of any intellectual property rights, like a trademark, or let's say in case of a distribution agreement, it is a right authorizing the distributor to sell the products of the company in the market or a particular given market. So all those details are the essential elements which will help us form a particular contract. So let's say if you're working inside a organization, so if you're working within an organization, then you will have some business team which will help you identify these details. They will share these details with you, and after collating these details, you will put them on paper. There are some details or lessons uh, on our website contractdrafting.in. There is a beginner course, so I suggest you go through that. So some of the lessons capture that detail. This negotiation, as a lawyer, you may not control, specifically the commercial arrangement, uh, but uh, you have to understand, um, let's say there is a commercial requirement regarding payment. So parties will be negotiating the price, but you can suggest them that they should have a clause when this particular payment has to be made. So that payment term, the period, you can suggest on that, but it is for the parties to capture that in the contract. Uh, but let's say if there is a tax related requirement that you can control, as well as you can take help from your finance team. So if there is a reference that you have to include with respect to GST, or you want to ensure that the other side complies with the GST requirement, uh, if they have to provide some TDS certificates, you want to capture that in your contract. So all those things you have to think of, both from commercial perspective and legal perspective, and then include it in the contract. So before you create a contract, you have to think about the outlining of the contract. So let's consider one example. uh, let's say party approaches you and says that they want to buy a piece of land, You are an independent legal consultant, and the seller has said that they will take 10% of the sale value in advance, and they will execute an agreement to sell. This contract also has a clause that states that buyer have to pay 90% of the sale value within next 30 days, simultaneously with completion of certain formalities by the seller, and that on the final day, 30th day, both parties will execute a sale agreement. So in this particular transaction, you have to understand that there are two agreements. One is an agreement to sell and a sale agreement, and both these contracts have different purposes. And this is a very routine and normal trade practice for such transactions, which some of you may already be aware of. So essentially, in the first agreement, you have to capture certain clauses which identifies and puts an obligations on both sides that they will complete the transaction after completion of certain conditions, and on the 30th day. And then there will be a sale agreement which identifies what is the amount paid, what is the uh, particular land, piece of land, that has to be identified in the document that is being sold, who is buying, who is selling, what is the price, when is the payment being made, how it is being made, what will happen with regards to the let's say government taxes that needs to be paid. um, so all those things essentially will capture um, the transaction in a piece of paper, that is sale agreement. Let's consider another example. There is an MNC which is looking for an office space, and they have identified a suitable property, but the owner of that property is out of country, and they are not yet in the they will be coming back later. So they I mean, your client wants to ensure that the owner concludes a lease agreement once the owner is back in country, and they want to have some kind of protection by of a written arrangement, which should be a legally valid contract. So what they will do, what do you suggest for that? So one method that I can think of you can do is, uh, you will have a letter of intent kind of thing, where the owner provides a letter of intent that they are ready to sell the agreement based on certain terms. It can be a simple on paper written agreement, or it can be by way of email also. So how you have to capture the transaction on paper is something that you have to think of out of the box, because there is no written agreement that can be executed at that time. So your role as a contract drafter is not limited only to putting things on paper, but also to think about how to conclude a transaction, how to effectively ensure that this transaction will be held as a valid legal contract in court of law in case there is a dispute. Uh, there is another scenario where there will be a complex transaction involving more than two parties, and there can be more than two contracts for that kind of transaction. For example, in merger and acquisitions, uh, what parties do is that execute a term sheet. This consists of a broad commercial points and some legal clauses. It can have a conditional clause like the buyer will be conducting a due diligence, and if the result of due diligence is set to the satisfaction of the buyer, then there will be an execution of a definitive share sale agreement. So you also have to consider your client's perspective in the term sheet as well as in the share sale agreement. The term sheet can be a simple document, but the share sale agreement will be a very complex kind of document, which will also require clauses relating to compliances under, let's say, company law. It can also be under transaction relating to tax. It can be clauses pertaining to competition. It can be clauses related to intellectual properties transfer. It can be clauses on payment of stamp duty. So there are several things that you will have to think of. It won't be just a share sale agreement, but it will include clauses on other aspects as well. Uh, some other example can be a, let's say, project development transaction. So in these case, parties may execute a memorandum of understanding before executing a detailed project development contract. So these kind of documents will be quite complex, and you may get an opportunity to draft or review such kind of documents. Maybe when once you have a, let's say, if you're working for such a company, or you get an opportunity later in point when you have sufficient experience. So there can be situations where transactions are more complex. These are some simple examples which I have covered. There can be very, very complicated transactions. For example, a recent transaction which happened for acquisition of cement companies by Ambani. So you should read about those transactions from publicly available materials, how it was structured, what documentation was done, who paid whom, who was owning which company, what shares were held by one company. So it will give you an insight of how actual transactions take place, and you will learn about structuring a particular transaction. And based on that structure, which should be both commercially beneficial for both sides, it should also be tax beneficially uh, for both sides. And once you have captured the transaction, then you will put things on paper. So what documentation will be done, what type of contracts will be required, what permissions will be required. So everything has to be thought of. So let's say if you're working as an external law firm, you may get a idea about the transaction, but you will only be asked to complete one aspect, for example, drafting of share sale agreement. But if you're working as an in-house counsel for one of the companies, then you may get to cover and get to know about each and everything about that transaction. So these things will come in your life as a professional contract drafter at quite a later point of time, or maybe never. But you should be ready for that, and you should study more about such transactions. So once we have captured the essence of the transaction and details of the parties, then we move on to the outlining of the contract draft. So what basically an outline of a contract draft means, that once you understood the transaction and the purpose of that document that you have to create, then you get to include certain clauses. What those clauses will be, whether to include a particular clause in a contract or not, will depend on the type of transaction that you're supposed to be doing. Now let's say if you're doing a sale transaction for sale of um, immovable property, so there may not be a requirement to include a clause on intellectual property transfer, uh, unless mm, it is a part of a larger transaction like sale of the company itself, and that particular land is being owned by that particular company. So in that document you may include IPR clause to protect uh, transfer of trademarks of the originating company or the company who is being bought. Now let's go back to a simplest transaction, which I think will help you understand. Uh, just a second. I'm back on laptop. Give me a second. Yeah. So there can be a draft where you have to capture some commercial elements of a transaction. These can be, let's say, scope of service. It can be a contact list. It can be a specification of a particular machine. So these things can be captured in a schedule to a contract. For example, in an EPC contract, you will have a separate schedule for scope of works, fees, payment terms, uh, construction schedule, manpower plan, technical drawings, and all that. Uh, but if you move to a simpler document like a non-disclosure agreement, you will not need to have such kind of schedules. So the essence of this discussion is that whether a transaction is simple or complex, you have to understand the transaction in and out. You have to then understand your client's needs, and you also have to understand the counterparty's requirement and what they have essentially negotiated with each other. So once you have that fair idea, then you can analyze the commercial and legal risk that your client will face, and accordingly you will have to prepare a draft. Once you have that particular draft, then you move on to putting things on paper. So now let's move to what those uh, clauses can be. So for the purposes of discussion, I have kept uh, very basic requirements. Hopefully you will be able to understand. So a particular contract is not just a group of legal clauses. They must reflect the parties' meeting of mind that we have read about in the contract law class. What is a contract? So a valid legal contract must capture the meeting of minds. There should be no doubts about it. So your contract draft should be such that it reflects parties' understanding of the transaction as they view it, not as you view it. Uh, there are disputes between parties after signing of the contracts because the contract drafter has committed a mistake and the language is little bit confusing. So it is open to interpretation, and that gives rise to disputes. Thank you for that. And so the contract can be divided in few sections. The first part is basically introduction about parties, and there is recital. Recital is basically explaining the background of the transaction. Then the main clauses like scope, the commercial understanding, uh, for example, the price, payment terms, delivery terms for the supply of goods, and all that, and then rest of the legal clauses. Then we have to, as a contract drafter, we have to ensure that the clauses are the precise reflections of the transaction. They are no less, no more. If you have captured that meeting of mind of the parties, then you are successful as a contract drafter. If you are failing in that area, so no matter how well you have written, whatever smart language you have put, if there is any confusion in your clause, if it is open to interpretation, then you have failed as a contract drafter. So it's a very, very critical role. So you have to respect your responsibility. You may have heard that a contract should be concise. The language should be having clarity in it. So the essence of that keyword is that include any word or a sentence only if it is required. If it is not required, then there is no need to include any other line. You may think, because you know best, you are a legal person, you are a very knowledgeable person, so you may think, let's include this particular sentence also. But you have to think uh, from your client's perspective as well as from your counterparty's perspectives. Will they be agreeing to this? Because they have not commercially negotiated. They will hardly negotiate these clauses because they don't understand the legal part of it. So they will leave that to you. So you should be able to convince both parties, your client as well as your counterparty, that this particular clause is in their interest and this particular sentence is a part of that particular clause. So, as a legal person, as a contract drafter, you have to convince yourself first and then be ready to convince your client and counterparty, and then only cover that particular clause. Uh, let's understand it through an example. Let's say there is a sale contract. So you will include clauses on description of goods, delivery terms, inspection. In a service contract, you will include scope of service, if there is any qualification or limitation to the service. In a licensing contract, you will include nature of the license and the restrictions for its exercise. Now, let's say uh, there is a particular contract for service agreement, IT service agreement, and there is a contract for software license. Uh, but the software license IT service contract is a combination of two different types of things. One is a software, which is a product, and one is a service, which is basically a technical service. For example, let's say support service for the maintenance of that particular software. Now, if the transaction is that the client is providing a software which the client is building as a service provider, and then transferring the entire. Okay, am I audible now? So you were not able to hear. Oh, I'm so sorry. Actually, yeah, I am. I have joined through laptop as well as phone. So I thought my laptop was on unmute. Anyways, so should I go back? Yeah, yeah. So just let me know from when you did not hear me. Outline of the content. Okay, okay, okay. Actually, this page is also quite slow. So hopefully you all have your uh, presentation open. Okay, okay. Because my laptop connection is switching off and on, so I'm using my phone. Yeah, just give me a second. I'm trying to present the screen. Is it visible? Just a second. Okay. I think there is some issue with the sharing of the screen, but hopefully you can hear me. If anytime I get dropped, just let me know. Let me try again. I think I have some issues. Sorry about that. Still not visible. Am I audible?
Now you are audible. Earlier you were not.
Yeah, I'm getting some feedback.
What I did, I just pasted that sway link
Hmm.
also a presentation link in the chat box.
Okay.
What everybody can do, they can just click on that link. It will open the presentation in their window. However, you can just talk. It will give you the bandwidth to speak and with interact with everybody and give the lecture as well. I believe that would be a great way if
Yeah,
nobody has any.
I hope so. You guys can manage with that. If that's okay, I'll start. Suresh, are you still not able to hear?
We can hear you, Raju.
Okay, great. So it's slide number two, contract outline. I'll start from there. There's a butterfly just next after that. So what I was explaining, that once you have the uh, transactions details, the parties details, and you understand the transaction in and out, then you have to think about the outline of the contract. That means that you have to decide, depending on the transaction, what clauses you have to include in the draft, where to include them, how to include it. So that comes with some experience. But in simple contracts like a sale agreement or service agreement, it is basically a very basic requirement. Like the first part is the parties detail, then there is a recital section which describes the background about the transaction, how parties have arrived at that transaction, why they are going to enter into that transaction, all those things. There can be a separate definition section, or there can be definitions within the clauses, and there can be commercial clauses like scope, and there can be standard or boilerplate legal clauses like term, termination, indemnity, limitation of liability, intellectual property, governing law, jurisdiction, all those things. There can also be annexures in a contract depending on the transaction. You can decide whether you want your definitions in a particular contract clause itself, or you want to have the definitions as an independent section, or you want to have a definition as a separate schedule to a contract draft. You can also decide if you want to have certain information within a schedule or annexure, or you want to capture that as a part of the contract clause itself. So if it's a very complex transaction, you may decide to have an annexure or schedule as a separate document. Some of the commercial parts or technical parts you may wish to include in the schedule or annexure. If it's a simple transaction, you may want to keep the details within the contract body itself. So, a simple example would be a non disclosure agreement or a simple sale contract where you may not include any schedule or annexure. But if you are drafting an EPC contract, then you may have a separate schedule for scope of work, fees, payment terms, construction schedule, manpower plan, technical drawings, and all that. Moving on to next slide. So the requirement as a contract drafter, the first requirement as a contract drafter is that you have to understand the transaction completely, whether it is a simple one or it's a complex one. You have to understand the transaction in and out. Then, once you have done that, you have to consider your client's requirements and the counterparty's demands, and also understand the negotiations that they have done with each other. Once they have finished on that, you have to balance the client's requirements against the counterparty's demands. And then you have to identify the commercial and legal risks that your client will have. Once you have done all this, then you start drafting, not before that. So let's start with some examples. But before we do that, let's say what is a contract? So you may think that contract is just a bunch of legal clauses, but they are not. They are basically reflecting the party's intent. So we may have read about the meeting of mind between the parties for a particular contract. So if they have a meeting of mind on a particular transaction, that is the essence that you have to capture on paper. And this can be by way of recitals, clauses describing scope, or the commercial obligations they want to have. So all these things have to be captured on the paper. And what this should reflect is the uh, precise reflection of that meeting of mind or the transaction. It cannot be less, it cannot be more. Because let's say if you, as a contract drafter or as a lawyer, you think that there is some additional clause that should be included, then you will have to justify to your client, and also you may have to negotiate that with your counterparty, because counterparty will also have a legal representative who will be negotiating the contract. They will have commercial representatives who will be negotiating. So you have to justify including that particular clause in the contract. So basically, as a contract drafter, is your role is not limited to capturing of transaction and putting that on paper, but you have to think about why you are putting something on the paper, whether you need to put it on the paper or you do not need to do it. You may have read somewhere that contracts must be precise, they must have clarity. So by this it means that whatever sentence or word you are including, you must be very sure why you are including it. It has to be precise enough, but it should not be confusing. So as a legal person, you may think that, okay, I think this will protect my client's interest, so I should include this sentence. No, if it is something that can be avoided, it is not adding any legal value for client's protection, or you think that you may not be able to convince the counterparty to have it included, then you may drop it. You may use it as a tactic for negotiation, that you initiate, you include that particular clause, and later on drop that clause. So that can be one way of doing things, but you have to, at the back of mind, always be ready to understand that the transaction, the meeting of mind, has to be put on paper, and it has to be put precisely what parties require, and specifically to protect your client's needs. So let's take some examples. Uh, in a sale contract, there is a sale of goods, so we'll have some clauses on description of goods, delivery terms, right to inspect, payment terms, and all that. In service contract, you may have a scope of service or limitations to that particular scope of service. In a licensing agreement, you may have what type of license is being granted, or what is the product or the IP that is being licensed, what are the restrictions relating to that. So for example, if you say you are licensing your trademark to a distributor, so you may restrict the use of that particular trademark by the distributor to a certain jurisdiction. So you may have a separate distributor agreement for, let's say, the whole of India. So your distributor may sell the goods under that trademark within India, but not outside India. So you have to put the clause relating to that. Now, all these three transactions are different: sale of goods, service contract, or a licensing agreement. Now, some of the clauses may be present in one of the contracts but may not be present in another. So, once you start working on different types of contracts, you will get to know what type of clauses have to be there. I have been practicing for 15 years, and there have been occasions where I have missed to include very, very important clauses in certain contracts. So be very, very careful in how you are drafting if you are not missing out on something. So try to have a checklist. So you can have a checklist for a service agreement, or you can have some standard template for a service agreement. You can have a standard template for a sale agreement. You can have one for EPC contracts. So it's better to create templates for ease of reference. You may not get to use that template, but you can use it as a reference point. Let's say if the other side is provided a draft, you can use your template as a reference point and include something missing in that particular draft. uh, let's consider one patent license agreement. So Let's say if you're including an indemnity clause for breach of third party patent by the licenser's patent, which is very common clause. In EPC agreement, you will include a LD clause, liquidated damages clause, in case there is a delay in completion of the works. But you will not include such clauses in a sale agreement for immovable property. So, what type of transaction is there will determine what type of clauses have to be there in a contract relating to that transaction. Now, the most important thing as a contract drafter is that you keep going back to contract law, keep referring back, keep track of the latest developments of contract law, uh, because things are changing every day, every month, every hour. Supreme Court is deciding on, let's say, it is deciding on arbitration matter, which affects the parties' clause on jurisdiction or arbitration clause. It is deciding on tax matters, or let's say deciding on patent law. So all those things are there, but it is affecting your contracts. Supreme Court or High Courts may decide on some essential clause or section of Contract Act. So you must always be abreast and keep yourself updated about those sections. So keep reading, keep reading, keep reading. So having a regular knowledge, periodic updates of law is a very, very essential requirement of a contract drafter. So give some time to that study. Uh, let's say you are working in a field of IP laws. I understand one of you is doing that. Someone who is particularly doing that, if they get an opportunity to work on a share sale agreement, so they may not be aware about those things, definitely. But as a contract drafter, you should be ready for that. So being ready means you know the law, you understand the developments of law not only in the contract but also in company law, also in competition law. Uh, but there can, for example, there can be some restrictions under competition law on type of clauses that you may or may not have in a particular type of contract. So you must read the judgments from competition authority to understand what you can or cannot have. uh, I see many discussions about uh, personal employment area. So let's say if a person has signed a particular bond for working with a company for a particular number of years, whether it is a valid bond or not, that's a very key I mean question by the employees. So let's say if that employee is your client and they want to understand whether this particular bond is legally valid or not. So you have to understand the background of it. So my understanding is that if there is a training attached to it, if the company has incurred some training expense and they have taken the bond for providing that specialized training, then it is a valid contract. But just because they are providing a job to a particular employee without any specific training, the employee is himself or herself very skilled, knowledgeable about that particular technicality, then that kind of bond may be legally invalid. So enforcement of that one, because it's a uh, kind of impeding the employee's right to get themselves hired or to get another employment. So that's prohibited under contract law. But that prohibition under contract law comes with certain qualifications. So that understanding as a contract drafter has to be there. So it's not one thing as simply putting things on paper, but it is the understanding of law and based on that understanding, putting things on paper. That is your role as a contract drafter. Another example could be about trademark law. So let's say if you are drafting an agreement for trademark license, so what things you have to think of? It can be a restriction relating to use of that trademark pertaining to a area, or applying that particular trademark. Let's say if the company is using that single trademark for selling, they have different product lines. For example, take example of Tata Group. They are supplying chemicals, they are manufacturing chemicals, steel, car, and so many things. So if the they are appointing a distributor for, let's say, sale of car, can that distributor be allowed to use that particular trademark for selling some chemicals? No. So you have to capture that particular thing in the contract of the distribution for cars. Uh, let's say if there's an international contract, parties between parties who are based in two different countries. So the choice of applicable or governing law becomes a critical point of contention between these two. Somebody says it will have to be my country, it will have to be his country. So that negotiation has to be settled. How it is settled? So that settled that is settled based on the where the transaction is happening. So let's say if it is import of goods. So if I am importing goods and I want to have some protection on import of that particular good, where would I like to have uh, the warranty related to that particular good? I would like to have that warranty service delivered in the imported country. So the country of import will become the choice of governing law in that case. There can be a scenario where the import is of a software instead of a good. So, for example, Microsoft products. So, in that case, they will have a better bargaining power, and they will always say that in case of any disputes, the governing law will be of USA because they are based in USA. So, they will have that particular governing law. So, you have to think of many things. Uh, there can be a situation where parties will agree to a neutral venue, which is most often the case in case there is an arbitration clause. So, what is happening here? What is happening here is that if you're choosing a country of law as a governing law of a particular contract, if it is common law country and if it is a civil law country, the remedies that will become available to you will be drastically different. So, you have to understand what will be the implication of accepting a particular country as a governing law. If you understand that concept, then you will agree or disagree on that, or you will negotiate on having a neutral venue, or you will negotiate on having a common law country as a governing law. But you cannot have a governing law which is independent to the transaction. There must have to be some link to the particular transaction. In arbitration, the venue can be a neutral place, but the governing law has to be based on the transaction itself or the parties' relation to the transaction or parties where they're based depending on that. So there are many factors that you have to think of. Now let's consider the section 73 of Indian Contract Act. I'm sure you must almost have read about it. Now it's
Yeah, Rajiv, may I present that window in that? I mean, isn't that slide?
if you can
Yeah.
please go ahead.
Okay. I'm just presenting it. Let me. So whether everybody can see my screen?
Yes, we are at an outline. You can
Yeah. So
go forward.
let me just.
Yeah,
So
thank you. I think
yeah,
it's the last one.
yeah.
Yeah. I hope I apologize to everyone because we have exceeded the time limit. So we were to complete this session by 7, but it's 7:20. So I'm hope everyone is okay and can stay back for finishing it. Because after
Yeah.
completing this session, I have some information to share with you all. Okay. So, going back to this section, I suggest that you go and read it carefully. You read it multiple times. Only this section. Do not go into the case law, but read this section. This particular section is something that in your initial career you may have to negotiate around, because uh, let's say if you're doing a contract with your counterparty which is based in US, then they may want to have a clause on uh, damages, which is a very generic clause, and it will have clauses asking for the parties to be liable for consequential damages, which is not allowed under Indian contract law. So, if your contract is providing a governing law which is of India, so by way of that reference, you can negotiate. If your counterparty has agreed to an Indian law as a governing law because of any reason, then you can take that argument and you can ask them to comply with this requirement under Indian law, Indian contract law, and tone down that particular clause on damages. But if you have accepted to a clause on US law and on governing law, and there is no, even if there is no clause on damages, then you must be aware that although your contract doesn't capture it, your client may get in trouble and may have to be liable for consequential losses also. So, in your contracts, in addition to the governing law clause, you must also include a clause on exclusion of consequential losses. By that way, you will have two opportunities to negotiate with the counterparty. One while negotiating the governing law, and another when you're asking for the exclusion of consequential losses in the contract. So, understanding these concepts as a contract drafter will help you become a better contract drafter. Uh, the Hadley and Baxendale case, the authority which has started this concept, understand the core concept of that, why it has been denied, why in some countries the consequential losses are allowed, why civil law countries recognize it, why in certain countries it is not recognized. So you don't have to pick every country, pick some major jurisdictions like US, UK, Germany, France, some more countries if you can, you have time. So try to understand the concept from perspective of different jurisdictions. Then you will be ready to negotiate these type of clauses. Next is just a link to it. Yeah. Now let's say there is a sale of goods contract governed by Indian law, and there is no clause on exclusion of implied warranties. If you have read Sales of Goods Act, then you have to understand that Sales of Goods Act itself provides for what rights and obligations the buyer and seller has. But if there is no specific exclusion of an implied warranty, a specific implied warranty, then you may become liable for such warranty as a seller, and buyer may claim that warranty under law. Some countries will have specific legislations. So US has a specific legislation of sale of goods. So they may prohibit certain kinds of exclusions like limitation of liability on the uh, of the parties due to death or injury cases. It is called in Indian law also it's called strict liability concept, which is also a part of tort law. So understanding these concepts will help you choose the better governing law and argue for it, in favor of it or against it. So if you have to protect your client, you have to understand the transaction and you have to essentially capture that transaction truly, which is compliant as per law. Then you have to understand these concepts. Then we may have uh, read about valid, what is a valid contract, what is an invalid contract, what is a void contract. So we have to basically ensure that whatever you are doing, whatever you are basically starting from putting things on paper to execution and to enforcement of a particular contract. Everything has to be compliant with law. So let's say if you are drafting a particular contract of, let's say, hiring a contractor who will provide certain services, and as part of those services they are hiring some laborers, workman category. If you do not protect yourself against workman liability, if you do not make sure in the contract that the contractor must have certain contract labor license, they must timely pay for the salary and other dues to the workmen. They must also do the necessary compliances like PF and ESI deductions. They must file reports, and you also, as part of contract execution, ensure that before making these payments you have proper paperwork. So have ensured that the contractor has paid the PF, and then only you release the payment to contractor. So you make it a condition to the release of the payment of the contractor's payment. Now these type of things will become clearer once you start working with, let's say, any organization which face these issues on a day-to-day basis. It will become easy. But if you are an outside counsel, then you have to understand these through your own reading, through being aware about the disputes that are being taken up by courts, uh, by reading on these disputes. So you will get a fair idea about these. If you're working in in-house counsel, you may have an advantage of knowing the transactions, how they work, what are the commercial reasons for having a particular clause or not, because that is also very critical. Why your client agree to drop a particular commercial clause, or why they agree to even drop a legal clause. So you have to have a fair idea about that, because sometimes it's better to have uh, I mean only 9 clause instead of a 10 clause, because including that 10 clause may put your client in difficult position. So taking that decision is also part of your role as a contract drafter. Now, Section 10, as we understand it under the Indian contract, is consists of that it must be made with free consent. What does this mean? So there will be a clause on that the parties have entered into a contract with their free will. There is no duress. They have independently negotiated the contract with each other, and only because one party has drafted it, it doesn't put them in a situation, adverse situation. So these kind of clauses you will find. The parties are competent to contract, so you will have warranties reflecting that that the party who is signing, let's say individual on behalf of a party signing, he is competent to sign the contract on behalf of that party, and by doing that he is binding the particular organization. A lawful consideration. What is a lawful object? So whether your contract has a consideration or not. Consideration can be a non-monetary thing. So a party is doing something and another party is doing something. So both these things taken together can become consideration for of the contract for each other. What is the lawful object? So can you do a particular contract for a particular transaction if it is prohibited by law? So you have to understand things. Simple things are fine. For example, you cannot enter into a contract for marrying a child. You cannot enter into a contract for doing some criminal, getting criminal things done. Uh, and you have to make sure that it is not expressly declared as a void contract. So understand these concepts from the Indian Contract Act. Go back to your books, keep reading them, frequently revisit them, read the legal developments on those clauses, because that is part of your role as a contract drafter. Now, the satisfaction of these things will definitely make a legally valid contract. Fine, that's fine. But there are other considerations like whether you can have a sale of immovable property contract on, let's say, stamp duty of only 100 rupees, whether you can have a power of attorney, let's say, only on 10 rupees. Well, let's say you have an indemnity bond on, let's say, in state of Maharashtra on 50 rupees. So stamp duty is also something relevant, registration act is also relevant, So because these things will come in picture when your client will start asking, is it okay for me to sign the agreement on plain paper? Is it okay for me to sign the agreement on my letterhead? So these things you have to take care of as a contract drafter. Now, consideration is something very, very critical. Why critical? Because you will sometimes get an opportunity to draft a document which will have no consideration. So you'll have to create one. How you will have to create one is something that will depend on transaction. The simplest example that I can think of is a memorandum of understanding. You take any memorandum of understanding which a government entity is doing with a company, private company, and you will find that there is no obligation on the government or the company to do the things that they are saying they are going to do under the MOU. But in private transactions, this is not acceptable. So the workaround is to that is that you have some clauses putting an obligation on other side, and these clauses can be limited in scope. For example, you will say in a memorandum of understanding that there will be a due diligence that has to be done. As part of due diligence, the other side will provide some documents and information. So that's a fixed obligation. That's a compulsory obligation. That becomes the consideration of that transaction. So you have to be ready to work around things. You will have to think out of the box to create things or create a transaction, structure a transaction in a particular manner. So you have to be very, very creative. You will have to uh, understand the commercial part of it. You'll have to understand the tax part of it. You'll have to understand the in case you're dealing with a public company, publicly listed company, you will have to understand the compliances for public listed companies and accordingly have clauses relating to that. For example, if you're a publicly listed company which is listed on stock exchange, then you will find some clauses on insider trading also. If you're dealing with a international client, then you may find clauses on anti-bribery. So you must be aware about those concepts also. You may find clauses on dealing of handling of personal data. So awareness about these concepts, the law behind it is also required, because unless you understand it, you won't be able to put it on paper or negotiate around it. Uh, so coming back to consideration, what exactly it is. So the sentence is, when at the desire of the promiser, the promisee or any other person, it is not only the promisee, any other person can also do or abstain from doing something, or does or abstains from doing, or promises, even promises to do or abstain from doing something. Such act, abstinence, or promise. So it is not only the actual act or abstinence of it, even the promise of such act or abstinence is a consideration for that particular promise. So I hope you understand the concept clearly, which is not only the act or the abstinence of that particular act. So I will agree to do something, I will not agree to do something. Even that becomes a consideration. Or I promise to do something or not to do something. That promise itself becomes a consideration. That is the key that you have to understand and make sure that if you get into a difficult position where you do not find any particular consideration between parties, then you have to intelligently put that consideration in that particular draft. Now, mm, void versus voidable. So there are a list of some sections which describes what are void contracts and some sections which decides what are voidable contracts. I am not getting into detail of these sections. I suggest but you read about them. Then there is a concept of void ab initio. What will the implication of for the parties if they have entered into a void ab initio agreement? So there is a concept of equity. That concept of equity says that you have taken some benefits under a void contract, whether it became void later or it was void ab initio. In those cases, you have to return back or pay for those benefits. So that's the case law. That's Court of Equity's decision. The Court of Equity being Supreme Court and High Courts. That's a common law principle. Understand it. Because that is something outside the contract. So, as part of transaction, if you are aware or you perceive a risk that this contract may become void, for example, at a time when there was a change in law of service tax and all other taxes to GST regime, then parties were not sure how things will pan out. So they structured a particular clause that if things pan out this way, then things will be dealt in this particular manner. Something similar is going to happen when there is the change, if it will be proposed under the labor codes. So you should read about those areas also, because you may get an opportunity to draft a contract where the labor code is not enforced, but later on when they become applicable, it has to be handled. So your contract should cover that, how you're going to handle that. So read about these things. Now, a very important question for all of you to think about, understand it, and have a, if required, you can have a discussion on the forum, or you can have an independent discussion with your friends and colleagues. If your client is asking you to draft a particular agreement that you know is in restraint of trade or in restraint of legal proceedings, what you will do, how you will consider it, what will be suggestion to your client, think about it. So that's the final exercise for you. And one more thing, try to find out and read about case laws on non compete clause, whether they are allowed, if they are allowed, under what circumstances, what are the limitations to it, what kind of limitations are acceptable or not, in what jurisdictions non compete clause will be allowed, to what extent they will be allowed. Read on these two topics. So, this particular session, the first session, is basically making you understand what a contract drafter does, or what is expected from a contract drafter. As a contractor drafter, when we start in our college, we think it's just putting things on paper, capture the transaction, put the details in any manner, and it becomes a contract. It's very simple. No, it is not. So once you have that understanding as a contractor, because it's a very, very critical role, especially in organizations, they depend on the protection of their risk on their contract drafter. So as a contract drafter, you have to respect that and be always ready for that. Now, if you have any questions on the lesson, I can take them now, or you can ask me later, and then I'll take 5-10 minutes more to explain few more things which we discussed in the induction session last time, and some of you may have missed. So we can discuss that now also. So any questions on the lesson content, or if anybody is having any issue in understanding what I've explained? Anybody can raise their hand and start asking.